So what's the crash course on Wisconsin state-specific Castle Doctrine? Well, as of film time, here's what you need to know. It applies in one of three different areas depending upon where you are. It could be your dwelling, in other words, it could be your home, condo, apartment, your mobile home if that's where you live. It could be your business, and it can be as well your automobile. But keep in mind, you have to be in those locations. If you are walking up to your car and somebody is in the process of breaking into your car, that may be, depending upon your specific facts, a lawful use of self-defense. What it will not be is a Castle Doctrine. You have to be inside your automobile. You need to be inside your home. Keep in mind that there are certain triggering conditions that need to be met. They need to have either broken into one of those places or be in the process of breaking into. So you cannot do something silly like invite someone in. If somebody does come in through invitation, not through force, then if for whatever reason the case does turn into one of violence and you may feel like you are justified to be using self-defense, that may be a valid self-defense claim. What it will not be is a Castle Doctrine claim. Generally speaking, here's how Castle Doctrine works. In Wisconsin, in order to use deadly force in self-defense of yourself or someone else, you need to be in reasonable fear of imminent death or great bodily harm. Once that criteria is established through your defense team, then you can raise the privilege of using that self-defense. This is what we call an affirmative defense. However, in Castle Doctrine, if the certain triggering criteria are met, namely, for instance, if somebody's broken into your house or is in the process of breaking into your house, then it actually gives you a legal presumption where your defense team does not have to show that you were in that imminent fear of death or great bodily harm. Instead, what they have to show is the fact that, look, the triggering criteria for Castle Doctrine was met. Now there's a presumption that my client, you, are in reasonable fear of imminent death or great bodily harm, and now they can meet force with force. The state can still try to disprove this by showing that either there was no presumption, in other words, your defense team failed to establish the lawful criteria to show that the Castle Doctrine applies, or if it does apply, to somehow show that perhaps something else comes into effect here, to show that, you know what, really, there still was no valid self-defense claim. Generally speaking, if these principles are in place in court, they must do so beyond a reasonable doubt. But keep in mind, everything is so fact-specific that it's difficult to say how your particular case or how another person's case is going to look unless we have all the evidence in front of us.